Thanks very much, George. It's a pleasure to be here today, folks. I've known Katie and Pat for a long period of time. We've been working with the MSC and its member companies for a long time, and so it's a pleasure to be here and talking about, I think, what we've made in terms of successes and the status of the current oil and gas program. Matt, if I could ask you to go to the first bullet, or the first slide with 3 bullets, there we go. So again, my objective today in the next 10 minutes or so is to briefly describe comprehensive environmental laws that relate to oil and gas development in the Commonwealth. I'm going to be identifying some examples of the stringent regulatory standards, and I'll also be pointing out the multiple layers of regulation that we have here in Pennsylvania. So as you can see on this slide here, there's just a number of laws that I've identified that would relate to oil and gas operations in Pennsylvania. The focus today is going to be on the Oil and Gas Act, Act 13, its regulations. But it's important to note that all of these other acts also have applicability to operators in the Commonwealth. And one other point, when I was actually an attorney for the DEP, DER back in the 1980s, counseling the Bureau of Oil and Gas Management, there was a lot less interaction with the different bureaus than there is now. So operators now are dealing with not only the Oil and Gas Bureau, but the Air Quality Bureau, the Clean Streams Group, Dam Safety Group, solid waste folks, and so on and so forth. So it really is becoming something where there's a comprehensive enforcement under all of these laws. Matt, next slide. So with regard to the Act itself, Act 13, I just want to point out some of the examples of the expanded legal protections available under that particular act. Water management plans are now required under Section 3211. No person may withdraw or use water from any water source in Pennsylvania for the drilling or fracking of an unconventional natural gas well, except in accordance with the DEP approved water management plan. In order for DEP to approve that, they have to confirm there's not going to be any adverse impact on the quality and quantity of water from the stream it's coming from, and it's not going to be impairing any of the uses. And it also requires a reuse plan for the fluids. Next, we've got setback increases. We've had setback requirements for some time under the Oil and Gas Act, but under the current Oil and Gas Act, Act 13, the setbacks for unconventional gas wells they cannot be drilled within 500 feet measured horizontally from a vertical well bore to a building or a water well without written landowner consent. And that setback becomes 1,000 feet when you start talking about surface water intakes or water supply extraction points. And so again, we had the concept previously, but it was expanded under Act 13. And then finally, with regard to reporting obligations, there are a host of them. Katie's already mentioned, for example, the frac focus reporting for chemicals used in the stimulation and fracking of wells. There's also new requirements under Act 13 for transportation records, where operators have to record the number of gallons that were used in drilling and stimulating a well, identify where the waste was taken, by whom. There's notices to the DEP with regard to emissions, air emissions, identifying air contaminant emissions from any source that they operate. So again, overall, what we're talking about here are just examples of how the statute itself imposed new standards. As you see here, we've got a few examples of the Oil and Gas Act regulations that also have become more stringent since the time that Pat was talking about at the outset. One example of that is secondary containment. It's now required under the 78A regs that all regulated substances that are generated and managed during drilling and fracking and flowback have to be managed with secondary containment with a certain permeability standard and also have storage capacity for more than the largest volume of the single largest above ground containment structure. The idea being there's going to be something put in place to keep any particular spills from reaching any ground. But we do have also spill reporting and cleanup that's also been increased in terms of its obligations. Those obligations are pretty rigorous. As soon as possible, but no later than 2 hours after discovering a spill of more than 5 gallons over a 24-hour period, the operator has to clean it up, depending on whether or not it's less or more than 42 gallons. There are different standards. If you have more than 42 gallons, or you affect a water supply, or excuse me, a water course of any kind, you would have to comply with Pennsylvania's Act 2 standards in terms of the remediation. And there's a host of procedures associated with that. And then finally, as another example, water supply replacement. Pat mentioned water well protections that were available through casing requirements and such, but operators that do nevertheless find that they've affected a water supply have to restore or replace it. And one of the big changes after Act 13 in terms of this particular provision is the statute talks about the restoration, the quality having to be meeting safe drinking water standards, or if the water quality supply exceeded those standards, that particular term has been defined in the regulations to mean that if it was better than safe drinking water standards, then the operator is required to try to restore the water quality to that. Now, what you see in front of you is just a few examples of some of the kinds of permits you have to have, not only the well drilling permit, which I think Pat mentioned, that the fees, those fees for just that permit have recently gone up 150% to $12,500 for just having that particular permit. But on top of that, you have to have your erosion and sedimentation control permit if you have earth disturbance over 5 acres. And from my interaction with people that put those together, they can be a bear to put that together. You have to have it before you disturb earth. Some of the applications will be hundreds of pages long and cost tens of thousands of dollars to get that. And it's not something the DEP issues easily. There's a lot of work involved in getting that. I got references to GP5 and 5A, although admittedly there are a host of general permits that go by GP5 in Pennsylvania. The ones I'm referring to there are the ones that relate to the air quality restrictions associated with both compression stations as well as well sites. And so in other words, it used to be that with the exemptions from the plan approval and operating requirements, it was fairly routine that well sites would not really have to do too much in terms of getting a general permit. The way it is now is that there's a host of things that have to be done in order to be able to document whether or not you have VOC or methane emissions above a certain level, and that you must have leak detection requirements that have to be satisfied in order to be able to operate. I won't go into the others. Chapter 105 deals with the common things you need to get for stream crossings, and OG 71 deals with having to reuse the produced water. Matt, if we go to the next slide. So I mentioned at the outset that we have several layers of regulation. So we've been talking about Pennsylvania DEP, the state, what they require. Of course, there's a host of requirements that would apply in the federal level as well, potentially to the operation of well sites and pipelines. And I've listed a number of them here. One in particular I'd like to note is PHMSA, which is the Pipeline and Hazardous Materials Safety Administration. PHMSA is the federal agency that is responsible for overseeing pipeline safety. And just as an example of the kinds of things that they do with regard to pipeline safety, over the last year, they've issued a host of new rules that would relate to how operators of pipelines have to proceed to inspect and to report leaks and otherwise do things to ensure the safety of pipelines. One of the ones that I know has gotten a lot of interest is the so-called mega rule. Back in October of last year, PHMSA issued the first of 3 rules that would relate to federal pipeline safety applicable to natural gas transmission pipelines. And those rules just went into effect in July of this year. They impose new requirements for verifying pipeline materials, for reconfirming what's called maximum allowable operating pressure of certain pipelines. And it also requires periodic assessments of pipeline segments located outside of high consequence areas, including newly defined moderate consequence areas. Phase 2 and Phase 3 of the mega rule was initially expected to occur this year, 2020, but what we have been told is that it's unlikely that's frankly going to happen at this point until after the federal election. Next slide, Matt. So in addition to the federal and state, we've got municipal permitting. And as Katie had mentioned, there's thousands of municipalities in Pennsylvania. Many of them have their own zoning requirements. And so it's possible that you might have to get, if you're an operator, a permit from the local municipality. That might be one that's issued either by right or having to go through a conditional use or special exception process, which involves a public hearing. At that point, the municipality is able to impose various standards. It is certainly the case that the Oil and Gas Act itself does recognize that it preempts many ordinances, local ordinances that relate to the same features or the same purposes of the act, but particularly after the Robinson Township decision that was issued a few years ago by the Supreme Court, there is a lot of activity on the local level with regard to ordinances. Those ordinances not only purport to regulate operators, but they also authorize, as a matter of right, operations. Those particular ordinances are getting challenged these days by folks that don't want to have oil and gas activities in the area. And so on that level, there's a lot of activity on both sides of the fence. So we've been talking a lot about how we stack up, how we've done over the years with Pennsylvania's program. One way of evaluating that is to look at an independent third-party review. There's an organization called Stronger, State Review of Oil and Natural Gas Environmental Regulations. It was initially created in 1990 by EPA and the Interstate Oil Compact, which established guidelines for how one should regulate oil and gas waste by the member states. Since that time, in the late 90s, it was passed to a nonprofit organization that is a multi-stakeholder organization that expanded on those particular guidelines. Now, Pennsylvania has volunteered to have its program reviewed several times since the 1990s, including 2010, 2013, and 2015. And just as an example of how that process works, in 2013, there was a 10-person review team that included folks like the chief geologist for the Texas Railroad Commission, the director of Earthworks, Oil and Gas Accountability Project, the project director for Trout Unlimited, as well as other official observers, including, for example, in that situation, Delaware Riverkeeper and the Department of Energy's Natural Energy Technology Lab. And so you've got people that are really very intimately involved in that type of regulation, those kinds of programs, closely reviewing the Pennsylvania program. And the way that they interviewed it is that they interviewed a dozen people that were knowledgeable folks in DEP, including the deputy director of DEP's Oil and Gas Bureau, Scott Perry, and questionnaires were completed. And it was a very thorough process. We had some people from our firm actually attending the hearings that were occurred in Harrisburg, in which there was a lot of input provided to the program. And if we could look at the next slide, Matt, we talked about, Pat mentioned, have we made progress? Well, these are the conclusions that were drawn by Stronger. In 2010, after evaluating DEP's hydraulic fracking program, they concluded that it was commended because of the fact that the department had done so much in terms of trying to prevent problems. That included tracking water withdrawals under the Water Resources Act, baseline water quality testing like pre-drill samples, identifying, tracking waste that would be generated through Form 26R, and essentially encouraging source reduction and recycling. In 2013, DEP's program to evaluate radiation levels associated with unconventional gas was evaluated. It was found that DEP had basically had the first of its kind program that evaluated very closely the type of radioactivity levels found in various materials associated with unconventional natural gas. And that data showed, for example, that less than 0.5% of drill cuttings that were disposed in Pennsylvania's landfill triggered radiation monitors. And they also determined that the cuttings did not contain levels of radioactivity that would be considered harmful to the public. And then more recently, in 2015, Stronger evaluated the Air Quality Bureau as it relates to Pennsylvania's oil and gas program. One of the things that they noted is that Pennsylvania was the first state to implement leak detection and repair requirements as part of the permitting process, standardized permitting process for oil and gas wells. And I'll note that for each of these reports, the Stronger Committee determined that Pennsylvania's program was well-managed, professional, and meeting its program objectives. So again, I think we can determine that in addition to looking at the progress that Pat had pointed out with regard to environmental compliance, cleaner air, and so on and so forth, you're finding third-party organizations evaluating it and also giving it high marks. So those are my remarks. I'd be happy to participate in any question and answer. George, I'll turn it back to you.
And for you, Joe, it's not a question, it's a comment, but the comments coming in with the idea that, again, people are grateful that firms like Babst Calland are taking a look to see where we were in 10, comparing it to 11, comparing it to 12, and sort of categorizing and cataloging where we've been, what's new, and what has to happen ahead. If I'm not mistaken, you guys actually have an update you prepare once a year that's similar to that, correct?
Yeah, that's right, George. We put together a white paper, as we call it. Actually,
be careful.
I think it is.
I don't want those books followed.
I know. It's a fairly, I'd say, heavy-duty document we put together. Been doing this for 10 years. We find that friends of the firm clients really appreciate us doing this because we kind of look soup to nuts with, what the program is in Pennsylvania, what the DEP is doing, what the local municipalities are doing, what case law is developing as it relates to, title and, basically all the different facets of the operation. So this is something that we also provide to people if they are interested in getting it. And we found that a lot of the clients, even those in, might have their offices in Texas, look for it because of the fact that it takes a lot of effort to try to put this stuff into some context. Katie has been kind enough to help us with these things and providing the operator business perspective. But yeah, we've enjoyed doing it. It's taken a lot of work and we don't get paid for it, but we think it's something that's valuable because we think it helps to keep people educated, just like your show.
Well, it's obvious that folks are aware of it and they're appreciative of it.